If you sue your doctor in a medical malpractice case, is there a presumption of guilt that what the doctor did caused you harm and injury? You want to know the answer? Come join me for a walk around the neighborhood as I walk my dogs and I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no. There is no presumption of innocence or there's no presumption of guilt in a medical malpractice case. A medical malpractice case is a civil lawsuit where you, the injured patient, is bringing a lawsuit against your doctor claiming that he was careless, causing you significant harm and injury. The ability to bring a lawsuit is an inherent right that you have, assuming, of course, that your case has been reviewed by a medical expert who confirms that yes, you do have a valid case, that yes, your doctor was careless, that he violated the basic standards of medical care, and yes, as a result of those departures from the standard of care, caused you significant harm and injury. Now, when you bring a lawsuit, you are really seeking money as a form of compensation for all of the harms and losses and damages that you incurred because of what the doctor did, because he was careless. Now, I asked the question at the very beginning of this video, is there a presumption of guilt? Guilt or innocence plays no part whatsoever in these civil lawsuits. Why is that? Because this is not a criminal case. In a criminal case, when someone is charged with a crime, there is always the presumption of innocence at the very beginning, right? That's what they always say. The person being charged is presumed innocent until proven guilty. That may be true in a criminal case. That has no place whatsoever in a civil lawsuit. Instead, we are required to show that we are slightly more likely right than wrong that what we are claiming is true. And we do that with all the evidence and all the witnesses who saw and observed everything relating to your particular issue. Then we have medical experts evaluate those facts to see whether or not, yes, the doctor departed from the standard of care with what happened here. And did that carelessness cause you injury? Was it a cause of your injury? If our medical experts confirm that yes, your doctor was careless, and yes, that carelessness was a cause of your injury or injuries, then yes, now we have a valid case. So at the very beginning of these types of cases, you might think, wait a second, an attorney would not have taken the case unless they knew for sure that the doctor screwed up. You might be right there. Right? You might be correct in thinking that, hey, there's no way an attorney who works on contingency, meaning he doesn't get paid unless he's successful in getting you money as a form of compensation. An attorney is only going to be able to take a case like this if he gets confirmation from a medical expert that you do have a valid case. However, there is no presumption at the very beginning when an attorney starts to evaluate your case whether or not you truly have a valid case. It is only after a thorough, detailed investigation, which involves obtaining all of your medical records, which involves having medical experts evaluate every page of your record, can we confidently go ahead, assuming, of course, our experts confirm that you have a case. Only then can we go forward and proceed with a case. Now, you might be thinking, okay, so that guarantees that we have a valid case. Well, I will share something important with you. Although we believe that we have a good case, the defense is not going to agree. The defense is going to do everything possible to dispute and disagree with our factual interpretations of what occurred. They will hire their own medical experts to come in to dispute every single thing that we are claiming in your case. Now, you may be thinking, wait a second, I thought at the very beginning, after hiring you as an attorney and you hiring a great expert, and we have multiple experts, that yes, we have a good case. And now we have the presumption that the doctor was careless and caused you harm and injury. Let me share something else with you to disavow any of those perceptions. There is no presumption that the doctor did something wrong. Here's what happens. You believe in your heart of hearts that the doctor was careless. Our review of the medical records may confirm that. But that's not sufficient to go forward with a case. In New York, we are required to have a medical expert, at least one, review and evaluate your case, and the medical expert has to confirm that you do in fact have a valid case. The defense, looking at the same exact set of facts, now has their own expert evaluate it and miraculously come to a different conclusion and a different interpretation than what we have. So while you think that there's an automatic presumption that because our expert has said and concluded that we have a good, valid case, that does not exactly what happens from the defense standpoint. They will do everything possible to find a medical expert or medical experts to dispute exactly what we believe, to dispute our entire claim, not only from our standpoint of what was done wrong, but also the extent and value of your injuries. So don't for a minute think that just because we have gone ahead and obtained, as required, the necessary medical experts to show that we have a valid case, don't think that there is a presumption that the doctor is clearly liable. We like to think so. You would like to think so. But ultimately, if the case goes all the way and does not settle during the course of your lawsuit, it will be up to a jury to ultimately decide whether or not we, you, the injured patient, the injured victim, are slightly more likely right than wrong than what we are claiming is true. If the jury believes our version of the events and our expert's version of the events, then you are much more likely to have a successful outcome than if they don't. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens behind the scenes. As we go forward with the case, as we evaluate your case, as we confirm that you have a valid case, and now, guess what? Now we've got confirmation. There is no presumption of innocence or guilt in a civil medical malpractice case here in New York. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter happened in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day. By the way, if you want to see my dogs, let's see if we can get them down here. Here we are. Here's Bentley. Bentley is the black dog. And Daisy is the light brown one. Daisy, say hello, baby. Nope, she's too busy finding something, smelling something. All right, everybody. Hope you have a wonderful day. If you have questions, pick up the phone and call. Bye-bye.